Colleagues, I rise today in opposition to House Bill 6553 because when each of us decided to run for office, we did so knowing that elections are a zero-sum game. There are winners and there are losers in elections. For years, Michigan's elections have provided sweeping wins for the majority party in this body, and in those years, this body has never once indicated that it had any issue with the powers entrusted to the positions gained during those sweeps, particularly within the executive branch. Some of my friends on the other side of the aisle have had up to 6 years to address the issue raised in this bill, but curiously, it wasn't urgent until the majority party experienced some defeat of its own. My people, Mr. Speaker, did not send me to Lansing to play partisan politics or to circumvent their choices that they made at the ballot box in November or the Novembers of the past. They sent me here to help create jobs, to make sure that our roads are fixed, their health care is affordable, and their water is safe. They sent all of us here to work in a bipartisan manner with all other officials that were elected and trusted by the voters to represent them, including our Attorney General-elect. Not only do I believe that the bill before us today is unnecessary, because this body can already receive permission to intervene in lawsuits as it has done in the past, and as the sponsor of this bill has indicated, but as an attorney myself for more than 20 years, this bill is a clear and blatant violation of the doctrine of the separation of powers. In a court of law, the opinion of a state legislator on a statute is irrelevant as a matter of law. Why? Because only the language of the statute itself is the actual voice of the legislature. Other opinions are mere political machinations or the fun, sordid stories about how we make sausage here in Lansing as we engage in the rough and tumble of politics. But once a bill is signed into law, our individual opinions, or the opinion of a bare majority of us, is no more important than the opinion of any other citizen. Neither a sitting judge nor a practicing attorney needs to hear our opinion in a court of law, because the judiciary and its officers of the court, including the Attorney General, are the ones qualified to determine the meaning of statutes and their constitutionality based upon relevant case law. Attorney General Cox did not need our opinion in court. Attorney General Schuette did not need our opinion in court, and Attorney General Nessel certainly does not need us to hold her hand in a court of law. This bill is an attack. It is an attack on the doctrine of the separation of powers. It is an attack on our system of law, and it is an insult to a duly elected Democratic Attorney General. Had last month's results been different, specifically in this particular race, I am confident that this legislation would not have been introduced. I urge all members of this body to rise above this last-minute and shameful power grab and vote no, because, frankly, it is beneath us, and we can do better. Thank you very much.